Hi, I'm Abby Faterick. I am here today to talk about the DS versus Trumbull Board of Education case that was recently decided on by the Second Circuit Court of Appeals. Judge Wesley wrote the opinion, and it just was released on September 17th of 2020. So I think that it's a really timely and important case to discuss as it affects special education and evaluations. It also goes on to define and clarify language from the Individuals with Disabilities Education Act, IDEA, which I'll reference several times throughout the presentation today. So the case is 19644 in the United States Court of Appeals for the Second Circuit, DS versus the Trumbull Board of Education. I just want to take a quick note before we get into it that I'm going to focus on the law principles that the court used to determine and support their decision. But you should know that there are several procedural issues with this case. There is a lot of things and back and forth and layers that if you read the full opinion written by Judge Wesley, you'd be able to get some more insight into this case. So I'm just going to kind of briefly go over those and focus really on what the court determined. So some things that include in the background is that it actually wasn't clear what evaluation the parents contest. A hearing examiner decides to focus on a specific evaluation, an FBA or a functional behavioral assessment. Then the case goes to the district court, and now they bring in something new about the statute of limitations. And ultimately what we need to look at is that it is 2020. And this started in 2017, and then also references back an evaluation as far back as 2014. So in 2020, we're looking at these evaluations and disagreeing with them that happened 3 to 6 years ago. And my concern and my focus is, where is the student and how could this have been prevented? How could the families and communities and schools have worked together better to come to a solution that would help the student? So here we go. Let's get into the case. So a summary of the facts. DS is a child with a disability who receives special education services at a therapeutic day school in Trumbull, Connecticut. He is diagnosed with ADHD and other developmental and behavioral disorders such as autism, and he's had special education services since he was in preschool. He's also regularly evaluated for behavior interventions and gets the functional behavior assessments done yearly. DS's parents disagreed with the 2017 functional behavior assessment that happened in March of 2017. And it came out eventually with the hearing officer and the board that they were also concerned with a reevaluation that was done in October of 2014. DS's parents requested a comprehensive independent educational evaluation, IEE, at the school's expense that would address DS's behavior and all other areas of his disability as well. So the original reevaluation date of October 17 was withdrawn. They withdrew their consent to give that reevaluation. And it's also interesting to note that a parent advocate and the grandmother joined in during the disagreements in May of 2017 that kind of led to this becoming a bigger issue very quickly. So once the parents requested the IEE, the Trumbull Board of Education refused that request and filed a due process complaint challenging the IEE request, which follows the IDEA regulations. And they did that in June of 2017. And during this time, the Board of Education was questioning the family or the parents, what evaluation are you upset with? Okay, and there wasn't really an answer given. So they had to assume that it was the most recent evaluation, the FBA, that was done in March of 2017. So then it goes in front of an administrative hearing officer who denies the parents' request for the IEE because there was no connection between the FBA evaluation that focused solely on behavior and the parents wanting an IEE, which is a full overall comprehensive evaluation. And the hearing officer said, you can't get a small assessment for behavior and then ask for a huge IEE that's a comprehensive evaluation. That's not how it works, okay? So then the parents appealed and the case went on to the federal district court, which also backed the hearing officer's decision. But what's interesting that happened here is that the federal court brought in the idea that the 2014 reevaluation was time barred by the 2-year statute of limitations from IDEA. So this hadn't been brought up before, and the Connecticut Federal District Court brought that up. So the parents want the district to still pay for this IEE, so they appeal it now to the Second Circuit Federal Court of Appeals to hopefully get judgment in their favor this time. So the Second Circuit had to look at 2 major questions. The first one is, does the district need to pay for the IEE that the parents requested? And underneath that question 1, we end up looking at what constitutes an evaluation, and can an FBA then be considered an evaluation based on that definition? And the second question to look at is, does the 2-year statute of limitations for filing due process apply to the IEE request? Simply put, the answer to both questions is no. So to answer question 1, an FBA is not an evaluation. An FBA is only part of the assessment strategy. Therefore, you are not entitled to an IEE when you're concerned with an FBA. Question 2 would be answered with that the statute of limitations is not a limit as to when the parents can request the IEE, given that evaluations can occur between 1 to 3 years. So there was a lot of research done by the Second Circuit and looking into the language used in IDEA to determine how this happened. Okay, so here's the reasons. The parents are not entitled to an IEE because an FBA is not an evaluation. The term evaluation means a variety of assessments that leads to a comprehensive understanding. There cannot be one single measure to make an evaluation. It must apply to all areas of the disability. So it's interesting that both sides, the parents and the Board of Education, originally thought that an FBA was an evaluation, and the parties were arguing about the hearing officer and the district court's conclusion based on the idea that the parents lost because they wanted a broader evaluation than an FBA is. Okay, and if you look at the quote from Judge Wesley, he states, our conclusion that limited assessments like FBAs are not evaluations aligns with both the statutory language and the purpose of the publicly funded IEE right. So the Court of Appeals rejected the determination of the hearing officer and the district court and went through all of the language and clearly proves, when you look at that opinion, that an FBA is not an evaluation. The second question answer here is that the 2-year time frame cannot apply to the IEE request because of the wording of the statute of limitations. Again, looking right at the IDEA language and helping to determine this. So a due process complaint is only filed by a school board to state an existing evaluation is adequate. The parents do not need to file a due process complaint as they did in this case. All they need to do is state that they want an evaluation done. The school gets the first right to conduct that evaluation. Once they do that, the parent can complain that it wasn't done appropriately, and the school then has to file the due process complaint to prove that it was an appropriate evaluation. Okay. Also looking at the evaluations that were conducted, the FBAs were done annually by the student, or for the student, sorry. Triennial evaluations completed and scheduled appropriately. There was one in October of 2014, and then the student was scheduled to get one in October of 2017. The school offered the parents to do it earlier, which the parents refused to have done. And oddly enough, if the parents would have allowed that to be done earlier and found an issue with that evaluation, then they could have requested the IEE. Okay. So that's some of the complications that are came along with this case as well. So ultimately, what is the significance of the case today? Well, the Second Circuit remanded the case back to the district court to resolve with these new determinations in place, this new focus on the language and the definitions. So the process set forth in the statute of limitations was not followed, and this caused a breakdown between the parties. Evaluations have to be provided at least once every 3 years unless the parents and the Committee of Special Education think it should occur more often. And this case really focuses on the idea of a committee of special education. That committee is supposed to be working together and bring everyone together to support the student best. A quote from Judge Wesley in the opinion says, separating the IEE process from the formal dispute resolution process serves to reinforce the focus on collaboration and communication among the IEP team. So if everyone had worked together better, then this would have been resolved in a timely manner and the student would have been supported. Historically, this is going to be a big deal because it shows that it is best to handle these cases between the parties without the courts and to put the student first. Okay, the 2014 evaluation could have been addressed by the reeval in 2017 and then in IEE had the procedures been followed correctly. But instead, it is now 2020 when the decision has been made and the terms have been defined. And we are 6 years after the last reevaluation that was done. So my final quote I want to leave you with is again from Judge Wesley saying, by mischaracterizing FBA's evaluations, the board unwittingly opened the door for parents who disagreed with a limited assessment to demand a comprehensive IEE at the public expense before the school had the chance to conduct its own comprehensive evaluation. So this is something that the Second Circuit felt very strongly about that needed to be stopped so that this couldn't be done over and over again. It shows how imperative it is to work together to support students and to make sure that we're working as a team and working on that IEP and the evaluations as the student needs. So that is my brief on DS versus Trumbull. I suggest reading the opinion for yourself. And also, if you have any questions or comments, I would appreciate your feedback. Thank you very much and have a great night. Bye.